I've been working with a buyer for several months under a signed buyer agency agreement. I've showed him many, many homes. A few weeks ago, I showed him a property which he really liked, but it only had a one-car garage, so he wanted to keep looking. I continued to send him listings, but shortly after our last outing, he became unresponsive. About 1 week later, I discovered that he went under contract negotiated by another realtor on the property that I had shown him. The signed buyer agency agreement gives him the right to cancel on 24 hours written notice, but he didn't do this. Who is the procuring cause and what are my next steps?
Regarding procuring cause, only a judge or an arbitration panel can determine who is a procuring cause in a particular transaction. Whether a broker is or is not the procuring cause depends on many factors, including the nature and status of the transaction, the nature, status, and terms of the contract, the roles and relationships of the parties, the initial contact with the purchaser, the conduct of the broker or the agent, the conduct of the buyer, the conduct of the seller, continuity and breaks in continuity, and other information. It is important to understand that the existence of any particular factor does not necessarily make or break your case. No automatic conclusions can be drawn from the presence or absence of any one factor. Procuring cause is defined as the interplay of factors which together demonstrate that the unbroken efforts of a specific broker were responsible for the buyer making the decision to consummate the sale on terms which the seller found acceptable. There is no standard procuring cause rule. Each claim of procuring cause must be evaluated on a case-by-case basis and on its own merits. As far as steps to take, we would first of all recommend that the brokers have a conversation regarding the issue to see if some type of amicable resolution can be reached. The buyer in this case should be reminded that he may have obligated himself to paying 2 commissions and that he may want to speak to an attorney. After that, there is nothing to be done until the property settles. Assuming the property settles, the agent, with his broker's participation, would file an arbitration request within 180 days of settlement of the property. At that point, mediation, either formal or informal, would be offered to the realtor parties. Depending on the local jurisdiction, the mediation could be voluntary, meaning both parties would have to agree to mediate the dispute, or mandatory, meaning both parties must attempt to resolve their dispute through mediation. If mediation fails, the case would go first to the grievance committee to determine if the case was arbitrable, and, assuming it was, it would end up before an arbitration panel made up of 3 to 5 local association realtors who are on the professional standards committee. Those realtors would then make an all-or-nothing decision in favor of one of the parties for the entire amount of the dispute. Once a decision is made, it is only appealable if one of the parties was denied due process. It is not appealable simply because the losing party felt like the panel made the wrong decision. As to an action against the buyer in this case, this would be voluntary arbitration, meaning the buyer would have to agree to be bound by a decision of the arbitration panel. If the buyer did not agree to arbitrate the case, the agent, again with the participation of his broker, could file a claim for breach of contract in court against the buyer based upon the brokerage agreement.